that's our goal in education, is to get as much information, as much education to all of our members. And if you look behind me, if you haven't noticed, we have a new logo, Learn More to Earn More. And that's certainly what we're trying to bring to you, is the kind of programming you need to be successful. So I want to acknowledge, of course, Alexis Bowen as the team lead in the committee, and I am the vice chair or vice team lead, however you want to call that position. And I'd like to acknowledge our other team members. Do I see Alexis? Are you back on?
I am. We're having technical difficulty at my office with the internet, so I'm on by phone. So I don't have my wonderful background up because of the issues here, but I'm going to stay on by phone until I can get in on the computer. But I'm excited about the things that our team has been working on this year for education. And as my co-chair Catherine mentioned, we do have this new learning series called Learn More, Earn More. And we're all excited about that because we want to bring you some more education that will help you learn some more, to put a little more money in your pocket so that you have the money you need to be with us in Women's Council, come to all of our meetings and all. So we had a successful At Home with Diversity. And then in January, we had a successful panel who talked about things that we can do to survive this changing market. In August, I will invite you to come and be in person for the August meetings, because we have another panel who's going to talk about assumable mortgages and things coming down the pipe that we hadn't even thought about yet to keep us successful and help us list more. One of the things that they're going to talk about is how, if you have a listing with an assumable mortgage, you can get more money for the house. So I want to invite you to do that, and to always be on our educational Zoom calls, which we have about 4 more planned for you this year. Our Madam President is on. I want to invite President Charmaine to say a word or two.
One word. Awesome. I just want to thank you all. You know, if you're a Women Council member or if you're not a Women Council member, we open this forum to you all. For this year, education is one of our goals. And it is important for us not only to grow leaders, but in Florida, I always say, educated leaders are grown in Florida. We grow leaders, we make leaders, and if you are not earning money, then how are you going to be able to pay your dues and to attend events that Women Council, your local network, is putting on? So I just want to thank our education committee. You guys, I gave you a vision and you guys took it and you run with it. Our executive line, so proud of what you're doing. And if you're not a Women Council member, we are teasing you here. Join us, and we promise we will educate you. Okay. Is Joanna here yet? She's not on us yet, but I cannot thank her enough for agreeing to do this. This is a big ask in the middle of the day for you guys to take time from your business, but it's worth everything that we agree. Well, it's the promise that we made to our members, and we're fulfilling that promise. So thank you all very much.
Well, I'd like to say that we've set a record for the number of people that signed up for this event today. And if I remember correctly, First Vice President Natalie said we had 301. So we met my goal of 300. And yes, we want to increase that to get to where we have 500 to 1,000 of our 2,000 members online with us. for these
Inquiring minds want to
educational
know how many,
meetings. So
I'm sorry, go ahead. I'm saying inquiring minds want to know
I
how
just,
many of the 300 are Natalie's. We
Yeah.
have a lot of Natalie Derricks coming.
Yeah. And I think you should just put the teaser out there, Alexis, that the next one coming up will be the insurance. The changes with
yes,
everything that is going on with insurance. And we will make sure to market that to you guys with adequate time, okay? So we are at 3:08.
And Alexis, would you like
all
to
right. So
introduce the other team members as well? Did you want to mention them?
no, I would like you to do that, Catherine. What I would like to do before you introduce the rest of the education team is to give a thank you to communications who worked hard with us to make sure that this message went out. And obviously it's working. So we have great teamwork going on at your Women's Council state level. And so, Ms. Catherine, would you acknowledge the rest of the members of our education team?
Yes, we're pleased to thank the remainder of our team that's worked very diligently on this and our other projects: Miriam Kelly, Tricia Roy, Kristen Val Holcomb, Tatiana Diaz, Carre Young, Cindy DaCosta, Renee Smith, Yarmar Woods, and Shelley Manenbach.
I think that our chief counsel is on with us now. Is that correct, Ms. Joanna?
Let's
All right, I'm not-
see. I'll
not-
check for you.
Make sure she's unmuted because we don't want to waste any more time. We want to get on with having her tell us about the condo central situation. And by the way, Miss Catherine is going to watch the chat box. And if you have questions, type them in the chat box and we'll make sure that you do get all of your questions answered today. First, we want to let Miss Joanna get through what she needs to talk about. Write your question down and get it in the chat box and we'll have her answer them for you.
I am not
So how we
seeing
doing?
her here yet.
I thought I saw a picture. So
I'm looking under
I
participants.
apologize.
Unless, what would she,
I'm
would
sure
she be
she
in?
is.
So can I make a suggestion? While we wait on her, and this is just, is Cindy Hayden here?
Yes,
Go ahead
ma'am.
and talk.
I
I'm
think
here.
so.
All right.
Yes.
Okay, Cindy Hayden, until we get our condo guest speaker up, Alexis just showed me when she's up. Can you just give them a teaser of what to come for the insurance, please? And just a minute, to keep time while we
Absolutely.
wait.
What we talked about were not only the changes coming, but how we are going to show you how each of those changes is giving you opportunities to list more property, and then also best practices when working with a buyer, as well as some programs to help get some grant money for repairs that may help lower your insurance, $2 for every one. So again, focused on making sure we're giving you information that you can use to get more business, but also, have those conversations with your client and prepare, because based on what we're seeing with the increases, I'm imagining there may be people that decide to sell and either downsize or move to a different area or whatever, but we're seeing 100% increases, and basically it's going to get worse before it gets better. Probably the next 12 to 24 months, it's just going to be hard. And so we've just got to, help people get to the other side. And like I said, we've got some strategies and ideas to share, and we're excited to do it, working with the education team.
Well, we talked, Cindy and I last night at length about the issues with the insurance, and it is very important that everybody learn the rules and regs of the insurance. Our intent on the panel that we're going to have is to include some of our strategic partners so that the insurance people can actually answer some questions also. I'm sure they can't tell us why they're, charging more money, but they can probably give us some, ideas on things we can do to get our costs down.
And I think the other thing that this webinar and what our focus is too is President Charmaine has a vision that each of us would contribute our fair share of $25 to our PAC, because as we're going to hear today, the advocacy that's going on in insurance as well, it's important for us to be the voice of real estate and have a seat at the table. And so right now, we continue to be the leaders in Florida, with 49% of Florida's major investors are women's council members and 70% participation. So while we're leading the way, as you heard Alexis say, Charmaine has some big goals, and we want to show you, but it's more than just giving. It's showing the impact and the difference we're making. And that's, I think, part of what today is about as well with the condos is, understanding where there's gaps. And for all of us at GUARD, we were up there encouraging them to do some things to improve the condo law and make it mandatory for a 3-day right of rescission and other stuff that Juana will talk about. But again, each of us, plays an important role, and we're just thankful for those of you that have stepped up, and invite the rest of you to consider to keep it in mind.
Is
The other-
Joanna on us yet?
I don't see her in yet. I'm trying
Looks like we
to-
lost Alexis too.
Yeah, I
What's
just got
that?
in on my computer.
There she is.
Could someone text Joanna or call her office or
That's what I'm trying to get the
do
number to
something
call her.
so that we can remind her she's supposed to be on with us? Hope she's not out trying to be gay somewhere and forgot that she was supposed to be with us. So while we're waiting though, Cindy, we've got some new condo writers. They do, affect some of the things that we're going to have to do, from here on in. These came out, I think it was March 21st. And so it's mainly the financials and whether or not there's going to be assessments and things. So can you comment on that, Cindy?
I checked
Yes.
one
I-
for you guys.
Yes, so the Florida Realtor or condo disclosure that came out was based on the legislation that came out last year. They decided to keep the rider congruent with what was mandatory in the state law. The state law did not mandate that you would have a 3-day right to review the milestone and the structural reports, which obviously put the buyers in a very bad place. One of the bills that is currently being worked on that we went up and supported was to make that be an equal condo doc, like the budget, like the rules and regulations. So I'm hopeful that that's going to pass. But I will tell you that a lot of brokerages are writing and enhancing their disclosure because the assessments that we are seeing are significant. And when there's money involved, whether we did it or not, there's odds that we're going to be sued or have E&O claims. So we're going to talk about, best practices and I'm happy to share a little bit about, what we're doing, which is not only the disclosure that we let them know to be aware that these could be happening, both the buyer and the seller, but also to follow it up with an email that says, hey, you signed this disclosure, make sure you understand it. Because in speaking with attorneys in our brokerage, they said that buyers will often say, well, I just DocuSigned all that. I didn't know what I signed. And we all know that the courts tend to side with the buyer or the consumer and say, well, they didn't know. So he highly recommended that when you are doing anything of that sort, to consider following it up with an email to them, just saying, hey, just want to make sure that you had a chance to read through that. If you have any questions, reach out for legal advice or anything else. So I think that right now it's important that our members know that there's a lot going on, and we just want to manage that risk appropriately.
So what you're saying, Cindy, is above and beyond what the state has out. The brokerages are putting together a separate disclosure, which is basically saying, seek legal advice. We're just giving you what we were provided. We're not responsible for the accuracy of the information. Something along those lines. Is that what you're saying?
Yes, and also detailing that, these new structural reports and milestones will evaluate nine new items, and the reserves will need to go to fully funded, things that there may be some catch up, there may be some exposure, and just really making sure that people are aware of that. I know I saw a property I was looking at that was listed by Michael Saunders. I know their company had a pretty, I think it was 2 pages. Our company's is 1 page. I'm happy to share it somewhere if we, and other people might have some stuff, but I have forwarded those as I see them to Florida Realtors, so that as they update the forms, they can consider some of that. I think they know that we'll need more, but without the legislation really defining it, they were sort of erred on the side of being consistent with the policy that they had, which was the part that it's asked, but it's not mandatory. So for me, my best practice is I write it into my contract to make sure, right? Until we get that protection, I write it in, as well as the 12 months agenda and the minutes. Because again, a lot of sellers that live in condos truly have not been told by their association anything that's going on. So they're not really not disclosing. They don't know. So, and unfortunately for a seller, that doesn't mean that they're off the liability. If during the process it's discovered, the way the condo writer reads, that seller would have to pay all of that. So I tell the seller as well, better to disclose it up front than you're off the hook, Well, one of the things that we're going to have to get better at, and I had an issue, Cindy and I were talking about it a month ago, and I just closed on a condo, in that the documents need to be up there. When you're going to hit the button to upload to your MLS, if you're listing a condominium, well, if you're listing anything, all docs should be there. But more importantly, if you're listing a condominium, you need to be gathering that information and have it up there when you hit the button to upload an MLS, because we're going to have all the financials. We're going to have the 12 months of the meetings. Any past assessments I've put in the offers for the buyers, after the buyer, of course, has said to do it, that we want to know of any assessments in the last 5 years and what they were for, so that the buyer gets a picture of the pattern of assessments. And right now we've got tons of these condo projects all over the state that, as Cindy mentioned, they don't meet the reserve requirement because they have voted not to have reserves, or to keep their reserves low to keep their condo fees down. And now they're not going to be able to do that. They're going to have to get with the program and get their the reserves up. So I heard of one where they had a $10,000 assessment to get their reserves up, and then the insurance went up, and they had another $3,000 assessment, all within 6 months. And so those are things, again, that buyers need to be aware of, that we're going to have to do a better job as realtors to make sure they understand what they're getting into and that they are responsible. And if as we all know already, if the assessment has already been approved, then there's a form, at least in the FAR bar, where you check that the seller pays it at closing or before closing. And if it's not been approved, then you better try to find out how much you think it's going to be, because that's something that once you close, the buyer's going to have to pay for.
Joanna just
and
answered,
Alex-
and she thought it started at 3:30, so she's jumping on.
All right, thank you.
And I
Alexa.
understand that she's on under Alexis's name, so Juana, if you would just speak up.
Hello. First of all, I am so very sorry to be joining you late. I did have it on my calendar for 3:30, and I would fire the person who keeps my calendar, but that's me. So I'll have a discussion with
You're 7
myself
minutes
after
early.
the call. I will have a stern discussion with myself after this call. I'm so sorry. You all are such busy working professionals, and it is beyond acceptable for me to delay your program like this. So I apologize profusely. I am ready to go if you all are. So,
Well, before you ready to go, my friend,
Madam President.
I just want to thank you for doing this for us. We really appreciate it. And call me. We'll just leave you to get into it because you have a lot to cover. Thank you. I appreciate it.
Anything for you, Madam President. You all are in amazing hands. So I'm just going to start off with sharing my screen here so that we can get to the heart of the matter. Can you all see that? Cindy, give me a thumbs up if you see it. All right.
Yes.
So this is probably one of the most controversial talked about topics that we have. The condo law changes and the ensuing forms updates as a result of that. So we're just going to get started here. And I will tell you, we have a lot of ground to cover as it relates to these changes that we have made now with the FAR rider for the contract for sale and purchase. Now, this is one of our most commonly used riders, right? We track the usage of our form. So one of the things that prompted us to do this webinar is the fact that we know that this form is heavily used. It is a major, significant topic in Florida. And so we wanted to meet with you today, and I thank your leadership for giving us this opportunity. Now, by the end of this webinar, you always want to leave the audience with all of their questions answered. I can assure you by the end of this webinar, I will not have answered all your questions. Now, why is that? It is because, this bill, the original underlying bill is 82 pages of information that passed the legislature very quickly. I believe the one chamber voted on Tuesday, the other chamber voted on Wednesday, and the governor signed it into law on Thursday. So really, we didn't see this language until the Monday afternoon before it was first voted on. And then, as a result of that, we started getting tons of questions, not just from our realtor family, but also from attorneys and title companies and associations and others who had questions about this bill. And so the legislature said, calm down, folks. We understand there's some unanswered questions, but they promised that, or the stakeholders promised that they would go back and take a look at this. And so right now, as we speak, there are changes being proposed to Senate Bill 4D. So there are unanswered questions. We know that, but I also assure you that some of those questions will be answered in what we call the glitch bill, the bill designed to address the unanswered questions in the underlying law. So we took what we were given from the legislature, questions aside, and we said, what do we need to do in order to facilitate our members being able to successfully navigate these waters, right? How do we help our members understand what this 82 pages is all about and how to address this from the perspective of handling the matter for their buyers and sellers? So we recognized that we needed to amend Rider A. We did so, and this new version of Rider A has launched effective March 20th. So if you go to the forms in Form Simplicity, you will notice that while all of the FAR riders and the underlying FAR bar itself. This is the CR6. This particular form, you will know you're using the updated version of the condo rider because at the bottom of the form, it will say CR6X. Okay, so make sure you have the CR6X version, not the CR6 version of the form. Now, we also recognize that if we change the FAR bar contract, we're going to have to change the CRISP contract, the contract for residential sale and purchase that is created only through our forms committee, our being the Realtor Forms Committee, that is independent from whatever happens with our partnership with the Florida Bar. So that form has also been updated. The addendum to contract for the condominium as well as the cooperative, we'll talk about that shortly, have also been updated. So make sure you're using the right form. The CRSP 16X and the COOP2 for co-ops. Now, that's kind of some preliminary matters to tell you what to look for in terms of identifying the appropriate form, but let's drill down here. Why did we change it? Why did we have to make these revisions? Well, the legislature changed the law as it relates not just to condos, but to co-ops. So any association, organization formed under Chapter 718 of the Florida statutes or 719 for co-ops was updated as a result of Senate Bill 4D. And it was designed to address structural inspections as a result of the tragedy that we all saw in Champlain Towers. The law became effective on May 26, 2022. So once that happened, we had a dilemma. We knew that there were issues. We knew that there were unanswered questions. We also knew that there were some interesting dates in this bill, and we'll talk about those. So we had a dilemma to wait or not to wait. That was our question. And we decided because the law is effective, right? We needed to go ahead and make those changes. So a lot of people said, well, maybe we should wait, not just because of the glitch bill, but because we are creating an expectation in the mind of the buyer that they are entitled to reports that most people believe have not yet been performed. So if you go to the average condo association here in Florida and you ask for these reports, although the law is already in existence, they probably don't have them yet because the deadline is not until December 31st, 2024. So we recognize that rolling this out now means that you're going to have to educate your buyers a bit about the fact that the law is effective, but the compliance deadline, that's how you explain it to them, the compliance deadline has not yet come to be. So that may help you cut down on some of the buyers' confusion when they say, but wait, I thought the legislature said I'm entitled to this. You are if it exists. Okay, so let's get into that a little bit more. This new language was added and it references 2 new documents that buyers of resale condominiums may be entitled to. And these documents, the whole point of this bill was transparency and safety and definitely transparency as it relates to reserve funding for repairs and replacements. So this is, keep that in mind as we're talking about this. The motivation of the legislature was to provide safety information to buyers so that they can make informed decisions about the property that they're seeking to purchase. So on the form, on our condo rider, we updated paragraph 10 to address these changes. Now, we started off with these really long, drawn out paragraphs that got into all the nitty gritty. And the reality is, from a buyer education perspective, that was just going to confuse the issue. So we made some really basic changes to the form, okay? Milestone inspection summary. We added this underlying language. Pursuant to the statute, buyers who enter into contract is entitled at seller's expense to receive from the seller before the sale of property a copy of the inspector prepared summary of the milestone inspection report as described in statute. And then here's the key. This is the confusion, the area of confusion that I was talking about. They're entitled to it if, number one, their association, their condo, if it is applicable to them, meaning if the condo meets the definition that we're about to talk about. And number two, if a summary of the milestone inspection report has already been submitted to the association. So buyer confusion. Juana, my buyer says that their condominium association meets the definition, but they still were not given a summary of the milestone inspection report. Both things have to happen. They have to be in a covered condominium, and the summary has to have been completed. We'll break that down a little bit more in a minute. Same information with the structural integrity reserve study. This is document number 2 that is new that buyers are going to be entitled to. Pursuant to the statute, buyer who has entered into a contract is entitled at seller's expense to receive from the seller, not the association, from the seller, that's who has his obligation, before the sale of the property, a copy of the association's most recent structural integrity reserve study or a statement from the association that SIRS has not been completed. So when I say SIRS, I mean Structural Integrity Reserve Study. We like a good acronym in this industry. So when Marcia teaches this, she likes to point out that this is her, like if you put some hair on this figure that's beating its head against the wall, this is Marcia trying to understand the minutia of these laws because they are so detailed. And so we're trying to simplify them here, but we need to take a deep dive into the law to understand the very simple changes that I just showed you. Why, it seems simple, Juana, you only added a couple of sentences to the form. Exactly. For education purposes, for notice to the buyers, we added brief language, but I want us to drill down a little bit into the law so that you understand more why we took that approach. It will help you understand the rider language and provide you with an understanding of these new reports and why they are significant to the parties of this condo sale. But it's just a snapshot. And remember, these things may change based on the pending glitch bill that is working its way through the legislature. So let's get into the gist of it all. Okay, condos are now required to obtain. We talked about the seller has an obligation to deliver this, but let's back up. Before the seller's obligation is kind of created, let's look at the condo's obligation. The condo association is now required to obtain 2 new reports. The legislature is very detailed about these reports in this new law. They must be obtained at the latest by December 31st, 2024. And these are the milestone inspection report and the structural integrity reserve report. Milestone inspection really deals with the adequacy of the structural components of the building. It is focused on the safety of the condominium and the structures. The Structural Integrity Reserve Study, the SIRS, is a study that is basically addressing reserve funds for any needed future repairs or replacements to, common areas of the condominium. So that's the difference. They're both kind of dealing with physical condition of the property, but one is more focused on reserves and how those reserves will be used to fund those repairs. Those are the 2 reports. Now, the buyers of certain condominiums, not all condominiums, certain condominiums are entitled to these reports. And so we revised the rider. So let's look at the elements. Buyers of certain condos are entitled after entering to the contract. This is important because many of you who bring buyers to condos, the buyers may say, once they know about this law and they're more educated about it, they may say, hey, before I even sign the contract, I want a copy of these reports. Can they ask for that? Of course they can ask for it. The real issue, though, is their legal entitlement to the document does not begin until after they've entered into the sale and purchase contract. Seems a little counterintuitive if the goal is to educate the buyer, but quite frankly, that is the way the law is written. After they enter into the sell and purchase contract, then they are entitled to a summary of the milestone inspection report and a copy of the SIRS if those reports exist. So those are the elements. They get a summary. They are not entitled to the full milestone inspection report. But Juana, can they ask for it? Of course they can ask for it. The question though is whether they are legally entitled to that full milestone inspection report. And the answer is they're not legally entitled to the full thing. They are legally entitled to a summary after formation of the sell and purchase contract if the milestone inspection report exists. I know, clear as mud, y'all, clear as mud. The other report, the SIRS, they are entitled to an actual copy of the SIRS, but only if it is a covered association and a copy of that summary or that report has been provided to the association. If the SIRS has not yet been completed, the buyer then gets a statement saying that the report has not yet been done. Okay, there is no corresponding equivalent with the milestone inspection report. Right? There is no corresponding equivalent saying if a milestone inspection report has not been completed, buyer is entitled to a statement saying it has not been done. There is no corresponding equivalent. So make note of that. That seems to have been one of those things that we hope they fix in the glitch bill, because that's the intent of it when we're talking about buyer transparency and education. But for right now, only when it relates to the SIRS can the buyer rely on either a copy or a statement saying it's not been done. So let's break this down and let's drill down more into what is required with this milestone inspection report. First of all, not all associations are required to obtain a milestone inspection report. So who is required then, Juana, if they're not all required? Well, the legislature focused on older buildings and buildings that are 3 or more stories in height. So they're entitled, if it is a covered association. Not all associations are covered. Which are covered? Milestone inspection report obligations apply to buildings that are 3-story or more in height. And notice I have here in italics, each building that is 3 stories or more in height. You may have an association where all of the buildings are uniformly 4 stories. We're good to go. It applies, the height requirement applies to them. We'll deal with the second part later. If you have an association where you got a 2-story building, a 3-story building, and a 4-story building, they decided to be creative in their design, it only applies. The milestone inspection report requirement only applies to the building that is 3 stories or 4 stories, not the building that is 2 stories. All right. So that's the height requirement for milestone inspection reports. There's also the age requirement. Okay, and within the age requirement, there's a location requirement. I know, clear as mud. So you've decided this is an association that has 3-story, with a building that has 3 stories or more. Now you have to ask yourself, what is the timing? What is the age requirement for when you know this building meets the age requirement? It is 30 years or more in age. So if you have an association that is 30 years or older, 3 stories or higher, they must complete a milestone inspection report. But that 30 years drops down to 25 years if the association or the buildings are located within 3 miles of the coastline. Clear as mud. 3 stories or higher, the age, and it is commonly expected in legal circles, commonly expected, though not defined in the bill. We hope it'll be defined in the glitch bill, that you can kind of rely on the issuance of the certificate of occupancy in terms of whether or not it's 30 years or 25 years. That is a fairly good way to measure the age of the building, the issuance of the CO. All right, so those are the associations covered. Oh, let me tell you this, 3 miles or more on the coastline, they don't give us any guidance. Is it 3 linear miles? Is it 3 driving miles? What's the 3 miles? They don't tell us. Again, things we're hoping, this is why I say I will not be able to answer all your questions on this webinar today, but we're hoping the legislature will address these issues. Now, what's not included in the requirement to complete the milestone inspection report? The milestone inspection obligation does not apply to 1, 2, or 3 unit family buildings with 3 or fewer habitable stories above ground. I have a comment here that says, say what? Like, didn't I just say if it's 3 stories or more, then it applies to that association, assuming it meets the age requirement? I did. But then in the exclusion, the legislature decided to throw in this 3 or fewer habitable stories above ground. That phrase, 3 or fewer habitable stories above ground, only modifies 1, 2, or 3 unit family buildings. So, or unit buildings. So single family homes, duplexes, triplexes with 3 or fewer habitable stories above ground are excluded from the requirement to get a milestone inspection report. Clear as mud. All right. So we've kind of established who has to have this report done. We've established who's excluded from having this report done. So when do they have to have it done by? Well, according to the statute, by December 31st, 2024, associations need to have their milestone inspection report completed. December 31st, 2024, if they meet the definition, they must complete their milestone inspection report. So you're really saying, okay, if it's a building that's 35 years old, Juana, they have until December 31st, 2024. Yes. If it's a building that's 19 years old, by their 25th birthday, they're going to have this milestone inspection report completed. Okay, so that's the key there. And then the milestone inspection report has to be renewed every 10 years, regardless of your location within the coast. Clear as mud. Now, what's in this milestone inspection report? You know, I've kind of mentioned that it deals with safety issues. Well, the milestone inspection report, according to the legislature, requires, it can happen in 2 phases. So the first phase is mandatory for all covered condo and co-op associations. Phase 1, everybody has to have done by December 31st, 2025, or their 25th or 30th birthday, depending on where they're located within the context of the coastline. Okay. So what is it? It is a visual inspection by Florida licensed engineers or architects of the habitable and non-habitable areas of the building, a visual inspection. Juana, does that mean they only have to kind of take a look at it? Well, they don't really tell us what they mean by visual. The issue, though, is going to be these licensed engineers and architects have professional obligations that they have to fulfill. So I'm pretty sure they're not just going to kind of take a cursory look and see what it looks like. They're probably going to, you know, kind of deal with the actual physical condition of the building, not just look at it, but actually deal with the substance of their observations. Now, the association under statute must make the arrangements for this inspection, and the association absorbs those costs. Now, what does that mean, Juana, absorbs the cost? Well, technically, the association is supposed to pay for it. We suspect, though, that will get passed on in one way or the other to the unit owners. But under the statute, the association has the affirmative obligation to arrange the inspection and to pay the cost. Now, I need associations to plan ahead. because there are only a limited number of licensed professionals in the state who can do this study. I attended a session recently, and they said as of February 2023, there were 40,789 licensed engineers and 11,308 architects in Florida. So maybe if all they did was condo work, there'd be enough architects and engineers to go around. That is not all they do. And so associations really, really need to start thinking now, forming those relationships if they don't already have identified professionals who can start looking at doing this work for them. But they need to plan ahead, especially with this one, because not only do you have phase one that is mandatory for everyone that deals with that visual inspection of the safety and the adequacy of the structural components, but if during phase one, an inspector notes that there is substantial deterioration, that's the legal terminology, substantial deterioration, then further testing is going to be required. And additional inspections must be conducted to make recommendations regarding repairs to any damaged structural components. Okay, so maybe phase one, everybody has to do phase one, but maybe phase two if phase one notes that substantial deterioration. Once the inspection is done, once the milestone inspection is completed, then the inspector has an obligation to provide a copy of the milestone inspection report and a summary to the association and to the local building officials that have jurisdiction over the condominium. Okay. The report and the summary must be provided to both. Now, this report I mentioned deals with structural issues. The statute gives a little bit of definition in terms of what that means. It specifies that the report must identify any structural deterioration and the extent of that deterioration. Needs to make recommendations regarding repairs, identify any unsafe or dangerous conditions, and identify and describe any items requiring further inspection. This summary will contain all material findings and recommendation because this is the document that the buyer is entitled to. Again, can the buyer ask for the full report? Sure, they can ask. The legal requirement, though, says the buyer is entitled to a summary. So the summary needs to be fairly detailed. Now, we've covered that the buyer is entitled to the summary if it is a covered association, which means it meets the definition. Why is this important? Because remember, the legislature wants transparency, but for you, this is really important because the parties will be better informed about the condition of the building that is where the unit is being sold. That makes for more informed buyers. The more they know, the better. And then keep in mind, some buyers are not going to get a summary. This is the danger in rolling out the form now. Some buyers are going to see that and say, oh, it says here I'm entitled to, but it doesn't, they don't get to the if applicable part. So some buyers are not going to get a summary either because it doesn't fit within their criteria or because the timing, the deadline has not yet come and passed. This is a 19-year-old associate or a condo building. And so it doesn't yet trigger for them. There's no requirement yet under the law. So make sure your buyers understand that and you are able to communicate that to them in a way where they are not expecting you to deliver something that they are not yet legally entitled to. So is the buyer entitled to a summary? So this is a little mini quiz for you all before we move on to the next topic. Here's the first question. If I was fancy, I would do that PowerPoint that gives the question and then I give the answer. I'm not fancy like that. I have a hard enough time keeping my calendar, so I didn't make the cute PowerPoint that way. But pretend like you don't see the answer. If the buyer is buying a unit in a 3-story building that is 16 years old, does the buyer get the summary of the milestone inspection report? That answer is no. The buyer is not entitled to a summary because the building has not yet met the criteria to provide the milestone inspection report or to even complete it because of the age of the building. It's only 16 years old. The buyer is buying a unit in a 2-story building that is 30 years old. This is a trick question. Is the buyer entitled? No. The buyer is not entitled because the milestone inspection summary does not meet the criteria. So parts of the association might be covered if there are other buildings in excess of 2 stories that are 3 stories or higher. But because of the height of this building, the buyer is not entitled regardless of the age. No entitlement because of its being a 2-story building. Now, what if the buyer is buying a unit in a 10-story building and it's 31 years old, but it's, what's today's date? April 2023, and the report hasn't been done yet. Then the building, although it meets the criteria, the height and the age, because the deadline, the compliance deadline has not yet come and passed, then the buyer is not entitled to the report if it has not been done. Okay. So let's talk about the second report. Structural Integrity Reserve Study Report. Again, this one also deals with the physical aspects of a building, but it is more so focused on how reserves will be assessed, collected, and used as it relates to those physical aspects of the building. So any association is covered if the association existed on or before July 1st, 2022. Okay, if they're formed yesterday, not triggered yet. But if they existed on or before July 1st, 2022, it is unit owner control, not developer control. There's some developer requirements. We're not going to get into that today. That would take forever. But if it is unit owner controlled, existed by July 1st, 2022, and it is 3 stories or higher, then a structural integrity reserve study is due no later than December 31st, 2024. Okay. Now, what needs to be in this structural integrity reserve studies, this SIRS? Well, the SIRS is required when there are to be future repairs and it deals with the replacement costs of those common elements. It is again a visual inspection performed by a licensed engineer or architect. What do we mean by, the covered areas? Well, the legislature gave us a pretty good list for this one. And they say the SIRS will cover elements like the roof, primary structural components, load-bearing walls, floors, foundations, plumbing, electrical, fireproofing, where all of these things, and items where the deferred maintenance costs exceed $10,000 if such items failure to maintain would negatively impact systems. Okay. That's the legal definition in terms of the content and the scope of the structural integrity reserve study. This study is going to need to include the estimated remaining useful life and estimated replacement costs or deferred maintenance expenses for any of those common areas being visually inspected. It needs to also provide a recommended annual reserve amount for those issues. And the significance of this is very similar. The parties enter into the contract with knowledge. Well, after they enter into the contract, they have knowledge of the condominium that they are purchasing and how the amount of reserves will impact future assessments. So what does the buyer get? Remember, with this one, the buyer actually gets a copy of the report. And if the report does not exist, they get a statement saying that the report has not yet been done and delivered to the association. Milestone inspection report, they get a summary of the report. It is silent on what happens in terms of the buyer's ability to get a statement saying the milestone inspection report does not yet exist. SIRS, they get a copy of the actual report, or they are entitled to know that it has not yet been done. And again, this is a kind of visual representation of those two differences. Why am I beating this horse at the risk of animal cruelty allegations? Because your buyers are going to have expectations that they're going to receive certain things, and you need to be able to clarify this for them. So again, milestone inspection report, a summary, SIRS, they get the actual report or the statement. Now, let's look at some what ifs for the SIRS. Let's do a little mini test here for what we've talked about with the SIRS. Let's say an association has two buildings. They are both 10 years or older. One building is 4 stories and one building is 3 stories. If the buyer is buying a unit, again, in a 2-story building, is the buyer entitled to a SIRS? The answer is no. The associations are only required to obtain a SIRS for each building that is 3 stories or more in height. So keep that in mind, 3 stories or more. Now, if that same buyer had signed a contract to buy in the 4-story building, then that buyer is now entitled to a SIRS. Why is this important? Again, when you have condominiums and the buildings are varying in height, sometimes varying in age, right? We added a 3rd and 4th building 8 years ago, but the original buildings are over 25 years old or over 30 years old. You have to assess this based on the building that the unit is located in. Your agents may think ABC Association, oh, I've already gone down that road. They are not required to have the milestone inspection report or the SIRS for this particular reason. But you can't make that assessment just based on the association. You have to make it based on the specific building where the unit is located within that association. So make sure your agents understand that. Now, what if the buyer is buying a unit within an association that does not fit the criteria for obtaining a SIRS, but the association is not yet, that it does fit the criteria, but the association is not yet in possession of the SIRS? Remember, unlike the milestone inspection report, the legislature created an affirmative obligation on the association to tell the buyer and the seller to tell the buyer that the SIRS has not yet been completed. So let's go back to our writer. We made these revisions in this new, on page 3 in the new subparagraph 10B and C. It's amended to inform the buyer of these 2 new reports and to try to help them understand when they may or may not be entitled to that information. So we stuck again, it's very simple language to explain some really complicated concepts. We explored, should we do the 25 or more, the 30 or more? That the writer is already long, and it would have been extremely complicated to a buyer to try to explain some of this, especially where we know we're releasing a form that the legislature will likely change again as a part of this glitch process. So we tracked the statutory language, but we kept out the minutia, the specific details on when they have to give the summary milestone inspection report or when they have to give the SIRS. This is just kind of a visual graphic. You know, maybe you share this with your buyers. And we linked it, the elements of what's required to the statute, to the language of the statute and the language in the disclosure. And again, this is just a review. I'm beating this to death because we need a lot of repetition. I've been digesting this for 9 months now, and it's still very difficult to understand the minutia. So the more we beat it to death, the better. the buyer who has entered into the contract is entitled to receive from the seller, not the association. So if you're the listing broker, make sure your seller has this obligation. A copy of the inspector prepared summary, not the report, before the sale of property, which is interpreted as closing. When do they have to give it? Before closing. If it is a covered association and the summary has already been submitted to the association. But please note, the statute is silent on the consequences if the buyer does not receive that summary. There's consequences for an association that does not fulfill its obligation to perform them. There's no specific remedy written into the statute that says if the seller refuses to give the buyer the summary that they are otherwise entitled to receive, here is what happened. But theoretically, it could be a breach of contract, obviously, that would then fall to the default section of the contract itself. So review, beating the horse to death. When is the buyer entitled to the summary? Not until the buyer has entered into a contract. Who provides it and who bears the cost of providing? The seller. However, the cost of the actual milestone inspection report is borne by the association. But in this instance, in terms of the buyer and the seller, the seller can't charge the buyer for this document. Seller has an obligation to provide it. What is provided? The inspector prepared, not the seller prepared, not the president of the association prepared, the inspector prepared summary. So the association is not going to get the summary from the inspector and then write their own version that's more favorable to them. The inspector prepared summary of the milestone inspection report, both part 1 and, if the standard is triggered, the part 2 summary. And by when? Closing. Are all buyers entitled to receive their summary? No. Only if it is a covered association and the summary is not in draft, in transit, it has been delivered to the association. Right. Same with the SERS, color-coded to kind of look at the language of the statute and the language of the contract writer versus the legal obligations and the elements of what's required. With the SERS, again, buyer has entered into the contract. They can ask before, they're not entitled legally into after. It must come from the seller. A copy of it should come from the seller because they're the ones who have to deliver it. A copy of the SERS or statement that the association has not completed the SERS before the sale of the property. Okay, that's what we're looking at. So when is the buyer entitled to the SERS or the statement? Because remember, with the SERS, not milestone inspection report, with the SERS, there are two. When are they entitled to the SERS or the statement? After the contract has been formed. Who provides the SERS or the statement to the buyer and bears that expense? The seller. A little bit different for the developer, but again, we're not going to get into that right now. Does the time expire on buyer's entitlement for the SERS? Yes, but at closing. The buyer has to get it before closing. And what is to be provided? Either a copy of the report or ding, 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 a statement that this report has not yet been completed and submitted to the association. Big question. Okay, so Juana, with condos, if they do not get copies of frequently asked questions, other documents, there is a right of rescission. So surely then, with the importance of these documents, right, the legislature wrote in rescission. No, they did not. The legislature did not give us any rescission rights as it relates to the milestone inspection report and the structural integrity reserve study. So if a buyer doesn't get them and they show up the closing table, they don't really have an automatic right to rescind the contract. Can they say you're in breach? It's a covered transaction. It meets the age requirement, location requirements, all these things, and I was otherwise entitled to it. They can say the seller breached the contract. But what they can't do is automatically cancel the way that they do under the current condominium document requirement. Might the legislature fix that in the glitch bill? Maybe so. Those are the kind of inconsistencies that the legislature can address as a part of glitch bill creation. So stay tuned for that one. That might very well change in the next version of this. Now, what if an association does not timely obtain the required documents? I mentioned contracts kind of silent on the remedy for buyer and seller, but it's very clear for the association. And it's probably a good thing because I'm not bashing our association friends, but at the same time, I hear from members all the time who say, you know, I have a really hard time getting this stuff from associations. And so,
Yes.
yeah, yes, somebody said, yes, I know, I've heard it time and time again. And it is very possible that when it comes to this, they may not be rushing out to go get documents that prove they have not been diligent in maintaining the elements or the condominium buildings, right? So, and it's also possible that it's not that they don't want to do it, it's that they waited until, you know, 3 months before it's due, and they contacted the limited number of architects and engineers, and they were told, so sorry, we can't get to you until next summer, right? So there are a lot of reasons why associations may not meet this deadline. And the legislature is very clear here. If they fail to comply with the disclosure requirements, the inspection report, the SIRS, then they have reached their fiduciary responsibility to the unit owners. And this is important because any member of an association board, they generally are going to be covered from or protected from personal liability because they're operating a fiduciary to the whole. If they fail to complete this and the legislature says it is a breach of their fiduciary, then they could face personal liability as a result of their failure to do this. So this is why they really need to start working on this now. If officers or directors willfully and knowingly fail, then to get the milestone inspection report, again, breach of their fiduciary responsibilities. The DBPR's Division of Condominium Timeshare Mobile Homes, that's the agency under DBPR, the division under DBPR that oversees associations. They could take action. Don't know if they will or won't, but it's within their purview. And then the Community Association Manager Statute, the CAMs didn't get away on this one either. It now specifies that if a CAM is operating under a contract to manage an association, under a contract, they specify a contract specifically. So that's what we're working with here. And that association must obtain these inspections, and they fail to do that, then they too obviously could face some consequences because they are obligated to comply with the building codes as directed by the board. And again, DBPR also oversees the licensing and regulation of CAMs. So I've mentioned we're kind of in flux, right? So a part of your role is going to be educating your customer on where we are with this, not becoming the subject matter experts on condos. That's not even me, that's Marcia in my office, right? Because this is dense, complicated stuff, but making sure they understand that there are some obligations that allow them to request documents that they may or may not be entitled to, right? That you need to make sure they understand that, but don't own this process for them. So not many of these reports are going to be done. We don't know, especially with this glitch bill that may not become law until, assuming that it passes, until May, June, July, right? We don't know how many of them are rushing out to get this done until they're really clear on what it is they're entitled to do or required to do. So between now and December 21st, we expect some things to happen, and we're already starting to see some of this happen. If you got buyers who say, I want to now to own a condo. You know, we used to say condos are one of the last kind of affordable housing options available to Floridians. We are hearing increases already being proposed of six-figure, and these are high-end condos, of course, but six-figure assessments for unit owners to cover some of these issues. So we are likely to see an increase in special assessments for association, as well as increases in quarterly, monthly maintenance assessments. We are already hearing that that is happening. Make sure that they are clear on the fact that as a buyer, you may be looking at some additional costs of ownership in the future. And keep in mind, sellers, this might be an opportunity for some of you. Sellers may be a little bit more motivated to sell condos now that they know that they will be looking at these types of additional assessments. Common questions. Why do this now, Juana, if it's going to change? Why did the committee decide to do this when it will be months before the compliance obligation? Because the law is currently in effect, and there are some areas of the state where these studies are happening more quickly than others. So we wanted to go ahead and get this tool for you to educate your buyers and to put them on notice of what it is they are legally entitled to if those things exist. Another common question that we get, what's my job, Juana? You've told me what the association has to do, what the seller should do. What did the legislature say is the role of the real estate licensee, the realtor, in providing these reports to the buyer? None. That's the answer. None. Margie always taught, I picked up from her because I think it's an excellent way of looking at this. You are the source of information. You are not the source of the information. And I often tell our members, your role is to facilitate the exchange of information, not necessarily to own the fact that, this information exists or does not exist, or to, take it upon yourself to be the person to go down to the association and obtain this. If ever there is a time, if ever there is an area for you to start to build some legal insulation around you, it's here. Don't own the delivery of this. Don't own the confirmation of existence of this information. Please put that on your customer to do. Facilitate communication. Do not assume risk. But there are some things we want you to consider. If you're a seller's agent, if you're not selling, but if you're representing the seller or working with the seller, I should say, make sure you tell them to go seek counsel, not because, in terms of what it is they're legally obligated to deliver and all this stuff, not because you ever really expect them to pick up their keys and walk to their car and drive down to the attorney's office. You're doing that so that you document your file and say that you told them that this is an ever-changing area of the law, and they probably should speak to their counsel about this. Document your file accordingly. So when they say, no, I'm not going to do that, okay, fine. Ask the seller, when it comes to the milestone inspection report, ask the seller, do you have a report? At the listing, do you have a report? Maybe make note of that, that they have said, no, there is no report. If they have it, obtain a copy and give it to the buyers or the buyer's agent, right? We want to make sure you do that prior to closing. But if the seller does not have that milestone inspection report, they do not have that summary to give, right? Because that's what they're required to give, the summary. Make sure the seller checks with the association to ask them if they have a summary. They can check their website to see if it's posted there. They can also check with the local building officials, because remember I told you that report has to be delivered to the association and the building officials, so they could check there. But if the summary has not yet been submitted to the association, obviously the seller is not obligated to deliver something that does not exist, and the buyer may not be entitled to it. But keep in mind, you sign a contract on June 1st, closings on September 1st. That structural integrity reserve study milestone inspection report might get done before closing. And if it is presumed, it doesn't say this in the statute, but the contract talks about updating and keeping the information current to the other side. The seller's obligation would be triggered, and they need to get that to the buyer. So don't just check on the date they sign the contract, check periodically throughout the process as well, especially as we lead up to the 2024 deadline. Seller should always consult counsel, but again, they may not understand. But when it comes to a SERS, I want them to remember, ask the seller if they have the SERS in their possession. If not, you know, they can't deliver something that has not been created. So again, the SERS only goes if it exists, or they remember they have an obligation with the SERS to tell the buyer that it does not exist, and put the responsibility on the seller to determine that information with their association, because many of the associations are not going to cooperate with you all anyway. And so make sure the seller is asking those questions. So again, if they don't have it, like if the seller can't get it and the seller's not getting a response from their association, remember the seller has standing under 718.112A2 of the statute to address issues of non-responsiveness from their association. If the association declines to provide the statement, right, that the SERS has not yet been done, and they're not responding to the unit owner, don't own that representation to the other side. Make sure that if the seller is going to rely on information from the association or even non-information from the association, you are communicating to the other side that the seller has informed me that, right? So unless you got some confidentiality concerns, you make sure you don't own that representation. Now, if you're working with the buyer, same thing, you're just going to facilitate information. The buyer needs to be requesting this information as soon as the contract is signed in an ideal world, right? But remember to renew that request prior to closing, just to make sure the report has not been done prior to the closing date. If the association does not have the report, again, continue to ask during the intervals. And then if the reports are provided, encourage the buyer to do the same thing. Take this document to an expert, to your attorney, to someone who reads structural integrity information with some level of confidence and expertise, and you make an informed decision about proceeding based on the advice of that professional, not me. Make sure you build some insulation around yourself, because this is complicated information. This is not a seller's real property disclosure form. These are complicated documents, and you don't want the buyer to put you in a position of interpreting those. So a couple more things before I wrap up. Does the new law about milestone inspection reports or SERS, or the statement that the SERS is not available, cover co-ops? Yes. This covers not just 718 entities, but 719 entities as well. So what about townhouses? Maybe. If the townhouse is located within the control of a condominium or a co-op association, and it fits all the other criteria, the age, the location, the proximity from the coast, 3 stories or higher, then yes. But oftentimes you may see townhouses that don't fit that 3 stories or higher, and that may be why it does not apply to them, but it's possible. If the milestone inspection, is that interchangeable, right, with some of these existing reports that have been done pursuant to some other requirement locally, like, you know, in South Florida, where we say, oh, they have to do a 40-year study. The statute doesn't really address that. What really determines that is the content and the scope of the report that was done, right? Does that content, does the scope of that document satisfy the legal requirements created under Senate Bill 4D? If so, maybe, but I think that's a risky proposition for any association to take without verifying that information very carefully. One of the things associations might want to do is ask the professional who did that report, the engineer, the architects who did that report, whether or not they can reissue the report based on Senate Bill 4D. May cut down on some work, may cut down on the bill, may get it to them faster, but there's nothing in the statute that says that these previous studies that have been done will satisfy the content that is required under Senate Bill 4D. Now, I mentioned locals, 40 years, that kind of thing. Keep in mind, You know, this year I've talked a lot, and last year, a lot about geographic competence, because there are so many ordinances on the books across the state that vary in terms of what is required. So don't forget that there is certainly Senate Bill 4D, there's the glitch bill we have to watch, but at the same time, you may have a property that is located in an area where a local ordinance imposes additional requirements for safety inspections or other aspects of condominium life and ownership. Broward, Miami-Dade, Boca Raton, Aventura, Highland Beach. There are others. That is not at all an exhaustive list, but there are others that will have requirements. And so there's nothing about Senate Bill 4D that said locals can't have their own ordinances. So make sure from a geographical competence perspective, you have considered not just the statute, but also the local ordinances that may impact whether or not the seller has additional obligations or the association has additional obligations. Now, with that, I want to thank you for your attention as we addressed probably one of the most legally complicated, confusing pieces of legislation I have seen in a very, very long time. Well, yep. And the 52-page glitch bill is pretty much the same. But I will tell you this, we are committed. We did a seminar on this a few weeks ago. We are committed to following up with a what's new seminar on this glitch bill if it passes the legislature, to better help you understand how even the stuff that we've talked about today may ultimately change. I'm gonna stop talking now, take questions with one more apology to all of you for the fact that I cheated you out of 15 minutes, probably 18 minutes by the time we actually got started. So my apologies to you again for that. Any
Juana, no apology needed. It was worth the wait. Every bit of information, and we're just blessed to have you today. I want to ask anyone who has a question, in the interest of time, to please put it in the chat, and then we'll have Juana answer in like an orderly manner. So the first question we have is, what fulfills the summary qualification? How do we know if information is missing?
So here's the thing, you won't. You won't. What goes in the summary is going to depend on what they found. And remember, we're talking about potentially two summaries, right? Because you got the first phase one, which everybody does if you're a covered association, but then phase two is designed to be even more detailed, right? So some of this, I mean, the legislature gave some guidance, but much of this is just going to depend on the professional obligations that are imposed on architects and engineers and how they perform their work. It's like saying, what goes in the appraisal? Well, you know, what does USPAP say goes in the appraisal? And this is going to be much like that. Again, these are not seller's real property disclosure forms. And this is why I want all of our members to make sure they do not own the content, any of it. We facilitate information as it relates to this, but this is some complicated stuff, y'all.
Thank you. Thank you. Another question. Could you please give the numbers again on how many inspectors there are in the state?
Yeah, so engineers, there are 40,789. And architects, 11,308. Those are licensed in Florida, who may or may not do this work. That's the thing. That one of the questions that has been thrown around is, you know, these are kind of new creations, these reports, and will an architect or an engineer even feel comfortable doing this? And will their insurance coverage cover, you know, errors and omissions for this type of really detailed specific work? So it is not going to be a surprise when associations contact these professionals and say, will you do this work for us? And they say, nope, not worth it. Like, there's just no amount of money you're going to pay me to assume that kind of risk, because think about what happens if they get it wrong. Remember how we got here with Champlain Towers. And so they're going to be really, really reluctant, many of them, to enter into this world.
That makes complete sense. Another question, and normally I'd give the name, but because of our little snafu, we have like 20 Natalies on here. So I'm not doing that. I'm just reading the questions. Does the law have any ramification if the condo does not do what they're supposed to do?
Yeah. Yep. So for the officers, directors, and the association itself, again, they specifically clarified this is a fiduciary lapse on their part, and the importance of that. Unlike, unfortunately, they didn't do that for the FAQs, for the budgets, for all these other documents that you asked them for. They didn't go there with these, but because of the safety aspect of this, if they fail to perform their obligations and get these reports done and deliver them to owners and to deliver them, to the other side, like they could potentially face personal liability. And if I had to guess, there might be a lot of lawsuits coming out of this, because I think some associations are just not going to do it like they're supposed to, and then some are just going to get caught with the fact that they're not going to be able to find a professional to get it done for them because they're going to wait.
Right, makes sense. And then a follow-up to that, the same person is asking, if they don't receive the documents till closing, can they pull out of the contract?
The statute is silent. Right now, the statute is silent because with the other documents, those that are not as significant in terms of safety, they have a rescission right? And it's written into our rider. Unfortunately, with this one, I don't know if it was the haste in which this was addressed and passed, I don't know. But the statute is silent on what the buyer's remedy is. And so in the absence of something specific, now we fall back to, if we're talking about the FARBAR contract, paragraph 15, 16, and 17 that talk about regular failure of performance and breach of fiduciary responsibility. So it would be like anything else that the seller fails to do. The buyer would just have to decide, am I comfortable that I'm in a legally defensible position such that I can cancel this contract, demand my deposit back without the seller fighting me on this issue? And then if the seller does fight, we end up back in court. The beauty of the condo rescission is it is very clear, and the seller has signed a document saying they understand that the buyer has a right to cancel. I suspect, I could be wrong, but I suspect the legislature will address that in the glitch bill.
In the
Thank you.
meantime, Miss Joanna, suggestion would be, they've got paragraph 20 with a bunch of free lines down there to write on there, if this is not provided by X date or whatever by the seller, the buyer has the sole right in their discretion to cancel the contract right up to the day of closing, whatever. I'm not the attorney. I'm just simply saying, can you give us a language that we might possibly suggest to the buyer to put in the contract on paragraph 20, or maybe we make an addendum, whatever we do.
So I'm always nervous about drafting, but what I suggest to members when they're going to put pen to paper, because the courts say we interpret in the light most favorable to the non-drafting party. So in other words, if you put pen to paper, you better say what you mean and mean what you say, because the court's going to hold you responsible for it. But here's the beauty of this provision. There is already printed language in the contract for condos about what happens if the buyer does not get the other documents. So anytime you're going to need to draft something special, just mimic what's already there for, let's say, the milestone inspection report in the SERS, right? Just use what's already there for the rescission right for the buyer and write that in for the rescission right for the SERS and the milestone inspection.
Good advice. I'm sorry, Ms.
Excellent.
Blackman. Go ahead.
Thank you. No, that's a good question. Another question, is this going to be something else the seller will have to pay to get from the association, like an estoppel?
Well, So here's the thing, the statute says that the reports are done at the association expense. That's what the statute says.
Mhm.
Statute also caps transfer fees, statute also caps, will associations figure out a way to kind of pass this along? Probably. I mean, I don't want to be unkind to associations, right? But the statute says the association bears the expense of performing these inspections. And it says the seller bears the expense of kind of delivering it to the buyer in whatever way the seller does that. So they're not supposed to charge this or pass this along to the unit owners. That's what the statute says.
All right, fair enough. Another question, does this require full reserves?
Yeah, so there are some aspects to this beyond the reports, right? Beyond the changes to the FARB archive. There are lots of aspects to this beyond what we focused on today. Remember, 80-something pages of stuff. And there's information in there that prohibits the waiving of reserves now, right? So this is going to hit buildings where associations have been doing that really hard, because the chickens have come home to roost now. So if an association in the past has been waiving the reserves, for these physical conditions of the property, they're gonna have to pay up now. And this is what's gonna cause some of these really exorbitant assessments. No, they're not gonna be able to decide that they got a copy of the SERS and the SERS says that they need to have, remember, it has to have an estimate, right? And the point of that estimate is they are going to have to fund that. No more, well, it says $750,000. We're only going to do $300,000 and we'll just do the rest of it some other time. Those days are over and they're going to have to fund the reserve sufficient to cover these costs.
Well, I guess the question was, they have to fund immediately, or do they have a period of time to fund?
There are some delayed options, and even the glitch bill goes into this a little bit more, because and so I really don't want to talk about what the glitch bill said because I don't want to confuse the issue, but there is a recognition that this concept of fully funding those repairs is going to cause some major financial difficulty. Like, we're already hearing about associations deciding that maybe they need to dissolve, right? They need to terminate the association rather than go down this path. That's a possibility, but yeah, they're gonna have to pay for these repairs now. No more of this kicking the can down the road. If it's a delayed or, an installment, that's one thing, but they're gonna have to pay for these repairs.
Okay, another question. I understand what triggers the milestone inspection report, but what triggers the need for SERS?
So same basic concept. If it meets the definition, if it is what we call that covered transaction, then they have to do the structural integrity reserve study. And again, that is, and I'll go back to the slide. Well, I won't put the slide back up, but I'll just tell you. The SERS is 3 stories or higher, right? There's no age requirement like with the milestone inspection report. We're talking about an association that was in existence as of January 1st, 2022, 3 stories or higher. They're going to need to do the SERS. Doesn't matter how old they are with that one.
Excellent, excellent. Let me see. Scrolling down, we have so many comments. This is wonderful. Thank you for the information. A lot of requests for the recording. And what I'm understanding from the real Natalie's comments and Beate, that it will be posted on our YouTube. Am I reading that correctly? And that being said, if we get clarification on that, I believe we're done with questions.
I would like.
Beate or the real Natalie on to clarify that on the recording.
Yeah, uploading it to our YouTube educational channel and then sending that link out to all of you so that you have access to it.
Thank you so much.
To all our members.
Also, we have had a request, Ms. Juana, if we could have a copy of the slides If you could
Absolutely.
provide it to us, we can provide it to the attendees.
Absolutely.
This has really been awesome. We would love to reserve you when the glitch bill is passed so that we can do Condomania 2.0 and get back on this subject again, because I'm sure between now and the time that happens, we're going to have some condominiums close under these new rules. And we're going to have, some new issues that have come up or as a result of that. And we're going to need to learn how to deal with these issues. And then the workarounds, like you were saying, put something in paragraph 20 to state that they have to be provided that if the condominium applies. Now, it's interesting, you were talking about things that are not more than 3 stories. So if that's the case, then we're also talking about a 3-story, let's say, townhouse. And although it's not a condominium, the very word condominium tends to make realtors, buyers, and sellers think they're exempt. So it may be changing the name from condominium rule to, anything that's, above 3 stories. So I think that's going to be interesting because we're talking about apartment buildings.
Right.
Is that correct? So,
Well, it depends on if it's subject to the association. If it's formed under 718, that's the real question.
all right, so let's just say, well, we've got a couple more minutes, that I own an apartment building and it's 6 stories and I've got 30 units. And I'm 31 years old on my building. Tell me how that affects me as the owner of the building, et cetera.
So all of what we've talked about today, and this is the way the bill process works, everything we've talked about today has been additional language under Chapter 718 and Chapter 719 of the statutes. So generally speaking, the apartment complex, while managed, usually professionally, that person's usually not a CAM, that person's usually not administering Chapter 718 responsibilities under the statute. What I suspect, though, is that apartments are going to be subject, because this changed 718, but it also changed the building code statute. So I suspect that apartment complexes are generally going to be controlled under building control statutes and ordinances for the jurisdiction where the apartment complex is located, but not so much under this regulatory scheme, because they're usually not going to be formed, filed, registered with DBPR as a 718 or Chapter 719 organization.
So do you think, though, because there's a structure that is that old that, has the number of correct stories to it, that eventually they're going to reach out and make some new legislation to cover all of these types of residential dwellings? Because the same thing can happen in an old apartment complex as can happen in the condominium if they're not structurally safe. As far as fees owed is another ballgame, but structurally safe seems to be the basis for this whole legislation.
I think it could be, right? Certainly it could be, but I think it would be somewhat different. When I say it could be, I think that there is at least the possibility of future regulatory issues as it relates to other types of buildings. But for right now, they have not done that. And it would have to be different because there's a lot about this that talks about the responsibility of the association to perform these studies. And so if the legislature ever went down that path, they'd have to do so with something very different from this. They could still use age, they could still use height, they could still use those types of qualifications in terms of triggering the regulatory scheme. But because there is no association, also subject to DBPR regulation, the question becomes then if they don't do it, then what do they do about it? Remember, I said DBPR has authority here over the association and the CAM. It would have to be a little bit different when we're talking about an apartment complex, but it could be the same basic, structure, height, age-driven analysis.
We have another comment I think is important to read. It's from Shirley from Orlando. Said, thank you, Juana and WCR leadership and my education. I believe this needs to be for condos 2 stories or higher. I have personal experience on this and believe it needs to happen. They need to also give us information on how to get this done due to our statistics on being able to find someone to do these inspections and affordable.
So, yeah, could it be written to also include 2 stories or higher? Potentially. There's some changes in the glitch bill, not as it relates to the height, but I believe with the mileage from the coast, right? So there are some changes that are being proposed, I want to emphasize proposed, but to my knowledge, the height requirement is not one of those. I will pass that along to the public policy office though for Florida Realtors to see if there's been any discussion within the legislature about that. But for right now, they're sticking with the 3 stories or higher.
Okay.
I will say regarding the 3 stories, one of the things that we get often is, what if it's mixed use? What if there's a parking garage on the bottom and 2 stories on the top? What if it's, retail on the bottom and then, condos above the retail? We're trying to get that addressed for sure in the glitch bill to make sure we're clear on what they mean by 3 stories.
Did everyone get their questions answered that is in the chat so that we didn't miss you?
That's all I see.
Yeah, I just flipped back through it. Well, first of all, I want to go back to saying again, thank you so much, Juana. You more than made up for your tardiness with the fabulous information that you provided to us, and we dearly appreciate you taking time out of your busy schedule. It is the goal of President Charmaine, the executive line, and your education committee this year to provide interesting and great data for our members, because even though, we're known for making leaders, we really need to educate our leaders so that they can make a little more money, so that they can continue to be members of Women's Council and move up the line in leadership positions through Women's Council and then to the local associations, state and perhaps national. And it's because of educational things like this that they are able to do so. And we couldn't do it without the whole village who worked together to put this together. For our members, you will see more and more of our trademarked logo, learn more, earn more, because that's going to be a whole series, and hoping that that's going to continue through the other presidencies that are to come after President Charmaine. We're the first in the nation to do something like this with an educational series. Of course, Florida does lead in everything, in RPAC, in Women's Council members, in RRC members, and in members of the National Association of Realtors. Madam President, or anybody else on the state line that is on here, will you want to make a comment or two?
No, I just thank you guys for providing this forum for members. And I am hoping to see you all on the next one. And again, if you're not a Women Council member, you need to find the nearest, closest network and go sign up. Thank you. Thank you, Joanna.
Anyone else? Well, hearing no more comments from the peanut gallery, as education chair, I'm going to again say thank you to all of you. We've exceeded a record here, and we want to continue to do that. Thank you for all who helped out, for all the hard work of Miss Correa Young, who helped put the background together for Madam President, and everyone who contributed their ideas. We would welcome, if you have any ideas on education, that you reach out to me, Catherine Sakis, anyone on the state line, and let us know, because we want to bring the type of education that you need and want. So thank you all, and we'll see you for the next Zoom class and in person August 14th.
Thank you, everyone.
Okay.
Thank you,
bye-bye.
Susanna,
Bye.
for being on.
Thank you. Thank you.
Bye-bye.